Good afternoon, everyone, and thank you for joining us today. My name is Martina Farrugia, and I will be moderating this webinar. Welcome to the third episode of the Fenech and Fenech Maritime series, Talks with the Industry. During our first webinar back in February, we had discussed the implications of Brexit on the industry, while in our second webinar, we had discussed the implication of COVID on the cruise line industry. Recordings of both these webinars can be found on our website. After encouraging feedback, we are back today with our new episode titled Judicial Sales of Vessels, Challenges and Expectations. The judicial sale of a vessel is a last instance enforcement tool used by creditors in order to recover sums that are owed to them. It is an action with the potential to impact a wide range of actors, including naturally the defaulting ship owner, the financiers of the vessel, the crew on board the vessel, and of course, the new purchaser of the vessel. In today's webinar, we have with us key industry players who will be discussing their unique perspective on the subject. On that note, I will introduce our speakers. Joining us today, we have Mr. Tilman Stein, a director and senior legal counsel of Deutsche Bank AG. We have Mr. Christos Mangos, the CEO of Interunity Management Corporation. We have Mr. Paul Falzon, who is the International Transport Workers Federation's inspector in Malta. We have Mr. Peter Laurijssen, who is the legal director of Compagnie Maritime Belge. We have Dr. Anne Fenech, who is a partner in the Marine Litigation Department here at Fenech and Fenech Advocates. And we have Dr. Adrian Attard, also a partner in the Marine Litigation Department here at Fenech and Fenech Advocates. So the webinar will take the form of a panel discussion with our participants answering a number of questions each. I will remind our guests that they have been allotted a maximum of 5 minutes to reply to each question, and therefore they are kindly asked to keep an eye on the time. We will begin with Mr. Tilman Stein. Mr. Tilman Stein is a director and senior counsel of Deutsche Bank AG who specialized in ship finance transactions. After his military service, he studied at Albert Ludwigs University in Freiburg, Baden-Württemberg, Germany, and started his legal career at the Hamburg law firm Escher, Schumann and Commercial as an associate in March 1994. In June 1996, he joined Deutsche Bank as a group legal in Hamburg to counsel Deutsche Bank Ships Finance business. He then moved on to New York in October 2000 to work with the legal team in Deutsche Bank and the New York branch, predominantly on corporate finance transactions. Mr. Stein returns to Hamburg in October 2002 to continue working with Deutsche Bank Group Legal on the bank's ship finance business. So welcome, Mr. Stein, and thank you for joining us. So the first question I have for you is, what has the appetite for ship finance been over the last few years? Have you seen that the COVID-19 pandemic has affected this, and are judicial sales by auction a route that banks resort to in order to recover their investments when things go wrong?
Well, thank you very much, Martina. A warm welcome from Hamburg, moin moin from Hamburg. And that's all I'm going to say in the beginning, because I jumped right into the question, which I understand is like a threefold question. And let me split this up into the three part questions. The first part question, what has the appetite for ship finance been over the last few years? Now, I'm not a market man, I'm a ship finance lawyer, but I still have a view as concerns the ship finance banks. So this is predominantly what I will be answering. Having said this, to answer it bluntly, the appetite has decreased. And I think roughly for the following reasons. First of all, the length of the shipping crisis, which started in 2008. The banks have lost faith over time. As you will know, banks tried to restructure their defaulting transactions and loans in the beginning in order to bridge a certain time period, excuse me, until the crisis was over, but this did not work actually. And in 2015, 2016, a number of bulker vessels and container vessels came into the market, swamping it even more in this weak market. These vessels had been ordered under the assumption that the crisis would be over by 2015-16. At that time, the bank lost faith in the market to recover in the foreseeable future. The second point is that the crisis brought new players into the market. So besides ship financing banks, we now saw PE houses and funds entering the market, buying the defaulting loans, whole books from the banks, helping the banks, the ship finance banks, to clean their books. So we have a new player in the market. The third reason I would see are changes in the environmental requirements, so ESG. We consider shipping to be a brown industry, and as banks seek to finance on an environmentally responsible basis, shipping is sort of a kind of a problem. Over time, you know, banks are looking more critical at these kind of transactions. Then, and that's last but not least, there were substantial regulatory changes in the market. So regulatory scrutiny tightened and regulatory requirements were sharpened, leading to ever higher reserve requirements. So again, this is sort of kind of a stopper for ship financing banks. This is also why ECA transactions have become even more attractive over time. So in summary, for this first part question, it's lost faith, new players on the financiers end, regulatory changes, and ESG requirements. I personally think that the ship financing banks will never again reach the level it had pre-crisis.
Oh.
The second part question, has a COVID-19 pandemic affected the appetite for ship financings? Well, the first answer is certainly yes, but only for a couple of months. As you may recall last year, when it became clear that COVID-19 was actually a pandemic hitting the whole world, whole countries were being closed off, the world was under shock, and everyone and every stakeholder went into sort of a freeze mode. But over the following month, it turned out that the shipping industry was not affected as badly as other industries. For example, I do not recall that we had pandemic-related restructuring or deferral requests from our borrowers. To the contrary, if we look at the markets right now, tankers have gone up over the past month. Now, bulkers and container vessels are even breaching former highs. Let's hope that that will become a sort of a stable process and will not end in another crisis. So to answer that question, the answer is no if you ask about a negative impact, and the answer is yes if you ask about a positive impact. Third part question, are judicial sales by auction a route that banks resort to in order to recover their investment when things go wrong? I pick up on what Martina already said, certainly yes, but the general answer is certainly yes, but only if all other possibilities were exhausted. Judicial sales, you must know, by auction come with so many ifs and whens, and we have some experience in that mortgagees are reluctant to go down that route. Risks and uncertainties in terms of length of process, different requirements in different jurisdictions, and difficult to calculate costs make judicial sales kind of adventurous, and you may appreciate that banks do not like adventures. So a consensual solution is always considered to be the best and cheapest way when things go wrong. In terms of adventure, just a very quick hint, and then I'm done with that question, or with these questions. You may know that if you enforce into a vessel, basically the acknowledgement of the enforcement and the results is not based on law, but it's more or less based on practice. This is why the CMI has started the process at the UNCITRAL, or with the UNCITRAL, on the International Convention for Foreign Judicial Sales and Ships and their recognition. And this, of course, is a very important project in order to bring more security on the enforcement side.
Thank you very much.
Does this answer your questions, I hope?
It does. Thank you for breaking down your answer so clearly. Thank you. So your second question is, when things do go wrong, and the bank is forced to take this enforcement action against a defaulting vessel in an attempt to recover the financing, what does the bank look for in an enforcement jurisdiction?
Okay, well, you may appreciate that others write whole books about this question. And I just got like 45 minutes. So let me just give you a a couple of aspects here. What would a bank would look for? First of all, of course, for an established legal framework in the country where the enforcement is intended or must be pursued. Sometimes you do not have a choice. So laws and regulations should protect the mortgagee to the highest possible extent. Different enforcement jurisdictions means different protection. Just as an example, while the laws of most nations do not recognize maritime liens for necessaries, the US do. Necessaries is a pretty broad term, so you might have a huge amount of money that precedes your mortgage. So whatever is the legal framework is very important when you decide about enforcement. Secondly, the enforcement process must be clearly structured and should not impose burdensome requirements on the mortgagee. For example, countries like France and Italy, they require a judgment on the merits of the underlying matter, whereas Malta accepts the mortgage as an executive title. Exactly. So if you enforce in Italy or France, what you would have to do, you would have to run a process under the law in the country that governs the loan agreement, obtain a judgment, and then get that executed in the country, i.e. France or Italy or where you want to enforce. That takes a lot of time, 6 to 12 months, if the borrower would not resist, and only thereafter you could run through the whole enforcement process. You may not want to do that if time is of the essence, and if you want to keep things simple. Third point I would like to mention is official institutions such as courts, marshals, and other authorities must perform smoothly and timely. The best laws and regulations are worth nothing if execution in practice does not work. Example, I'm currently involved in a court procedure, second instance in India, Bangalore, and without the merits of the matter ever having been tried, 2.5 years have already gone by, because there were always other kind of reasons why the court would not want to try this matter. So you will not want to enforce in such a jurisdiction, would you? Next point is the relevant jurisdiction must offer the right tools. So if a bank would want to enforce by court-approved private sale rather than court auction, you should seek not to enforce where the law only allows for court auction. Malta is a very good place because it offers like everything. Then even if there is a smooth and speedy process to enforce into the vessel, the applicable law must also provide for a clear and speedy distribution process of the enforcement proceeds. We had cases where we enforced into the vessel in a period of like around 6 months, and it took us almost 2 years to get the distribution funds. Oh. That was, in this case, this was South Africa. So you would also have to take a look at that. And then last and certainly but not least, what is very important is a trustworthy, reliable, knowledgeable, well-connected with courts and authorities, harbor officials, and reasonably charging outside counsel on the side of enforcement, always seeking not to only follow instructions, but to critically accompany the enforcing bank, because the bank is usually abroad and does not know the rules and the practices on site. So a bank is very reliant on the professionality and trustworthiness of outside counsel. As I said, the question could be answered by a whole book, and of course the circumstances of each single case will be important to take the right decision. But that's all I would like to know to answer your question, and thank you for your attention.
Thank you very much for your reply. So we're going to move on to Mr. Christos Mangos now. Mr. Christos Mangos is a principal of Interunity Group and CEO of the Interunity Management Corporation SA, joining in 2009. He is responsible for the provision of financial and strategic development of the company's institutional partners, and since 2015, he co-chairs Shell's Maritime Safety Forum. In 2018, he co-founded BWise and serves as a director there. In 2019, he co-founded Socana. Mr. Mangos specializes in distressed debt workouts, conflict resolution, and intelligence profiling. Mr. Mangos completed his BA in political science at Yale University and his master's in science in shipping, trade, and finance at Closs Business School. So, Mr. Mangos, your first question. When targeting distressed deals concerning the judicial sale of a vessel, what are the main factors which investors would consider before getting involved? Are there any common red flags that they tend to watch out for?
Yeah, hi, and thank you very much for having me here today. Actually, it was very interesting listening to Tilman to hear it from the bank's perspective as well. I would say first and foremost, clean title is important for any investor. And this is, of course, primarily a factor of the jurisdiction affecting the sale, but it also requires recognition and endorsement from the vessel's flag. And clean title must not just, and by clean title, I don't just mean the elimination of maritime and statutory liens, but the jurisdiction must also have a means of addressing possessory liens. So in its most simple form, should you bid on a vessel which happens to have a full tank of bunkers, the investor wants to know that those will form part of the consideration paid for, either because the purchase will be incorporated in the purchase price or because there's a mechanism for purchasing it separately. And this aspect can, of course, become much trickier because, for instance, if you've bid on a vessel where there's newly supplied equipment or there's cargo on board, there's an associated cost of removing these, and the investor must have clarity on the obligation towards the owner of the goods and what exactly clean title means. Where does his responsibility and his accrual of liability commence? So that's I think, in my mind, the most important. And then we go to process. So the point on process can actually cut both ways. And by that, I mean a relatively easy and inexpensive process actually usually attracts a lot of competition. An expensive, cumbersome, complex process can actually dissuade other investors and reduce competition on the actual auction date. And I'm just going to zip through some of the process items that, as an investor, we sort of, I look at. The timing is obviously key. Shipping is volatile. And investment decisions are time sensitive. So from the moment you're the highest bidder, you want to be able to pay the balance of the proceeds quickly and have the bill of sale executed shortly thereafter. So investors, essentially, they're seeking the same immediacy that they would see with an ordinary transfer of title under an MOA. That's what we're looking for. Secondly, I'd say clarity of bidding. So it sounds obvious, but actually bidding processes around the world, they vary significantly. So you have the sort of regular open auction bid where the judges, they will raise in set increments, which is obviously the case in Malta. You have sealed bids where investors have the right to register their best and final. This is a once off. There's another aggressive system, which is the top-down open auction, where a judge, he starts from a high price and then reduces in increments, and he waits essentially until there's a first taker. Flawless auctions where there's no minimum price versus one where the judge actually sets a reserve value. And then protocol for a defaulting bidder. What happens? I mean, if the highest bidder defaults, does it go to the next highest bidder, or does the court set a new auction date? So this is obviously, significant information for an investor. The next thing is capital intensity. So this is primarily a factor of quantum of the deposit and timing between lodging the deposit and execution of the bill of sale. So the benchmark is, again, ordinary MOAs, where investors are happy to put down something like 10% of the value of the vessel. Once you start deviating from that, it makes it a little more restrictive. Then currency. So obviously the shipping industry is dollar denominated, but judicial sales will often take place in each country's local currency. So under these circumstances, you need to consider liquidity and volatility in the currency value. So of course, timing also plays into this. If you deposited 30% of the value of the vessel in Turkish lira and the auction doesn't take place for several months, you're going to have a lot of attrition of value. Next is access to the vessel. So this doesn't usually occur to people, but actually it's not uncommon for auction vessels to have been somewhat neglected in the months prior to its detention, its arrest. And a protracted detention period while awaiting a court auction, a sale date, can cause accelerated wear. So investors, they require unfettered access to the vessel so they can make sensible decisions on the prospective investment, but they also look for authority from the courts to obligate custodians to cooperate, which is a big part of it. And investors will also want the opportunity to examine the underwater parts of the vessel. And this can represent a significant unknown factor. So remember, if there's damage essentially that you find after the auction date, it's unlikely that any insurance policy will provide any coverage. Court flexibility, decisiveness, and clarity, that's actually a big one. So it's often the case that vessels are abandoned during the detention. So this can happen at any moment in time, from the first day that the sale application is made all the way through until after the deposits are paid. So under these circumstances, investors, we look for a court to appoint new custodians. We look for them to enter into contracts on behalf of the defaulting registered owners and take all measures to ensure continued safe custody of vessels on which we're bidding on. So unlike ordinary MOAs, there's also an awkward moment whereby the investor will want to place its crew on board and remove the custodians. In an arm's length, ordinary MOA, NSF terms or whatever, it's, this is a mature contractual process. In judicial sales, it's obviously less common and more protracted. Ease of appointing local representation is important. So the number, the height of the hurdles and the sort of the hoops that you have to jump through in order to obtain right of representation on the day of the bid is of course a factor. And then finally, I'd say geography. And obviously here I appreciate there's very little that a judicial system can do to have any impact on the geography, but it's a factor. Parameters such as nearest load ports, major shipping channels, access to shipyards are all considerations, especially when you consider that a lot of these vessels are sold out of class. So that's what I would say.
Thank you very much. I've got another question for you. So you have recently been involved in a few judicial sales in Malta last year. Can you share your experience with us? Did the Maltese jurisdiction meet your expectations? You've listed quite a long list of things that investors look for. What was your experience like in Malta?
Look, it was very good. So clean title, check. And I don't spend any more time on that because I know that people more experienced than myself will touch on this. So in terms of process, timing, it was relatively expedient, even in the circumstances where the last judicial sale I attended was during COVID. So it was good. It was very, let's say, a very welcome, let's say, surprise. Capital intensity, fine, check. Currency, by virtue of adopting the euro, obviously, check. That's fine. Euro is a major currency, predictable. Access to the vessel was fine. Ease of appointing local representation, no idea, because I actually went there myself. In terms of geography, obviously there's lovely weather in Malta, clear waters and good topography. The food is good. Perhaps more to the point, it's obviously on a major shipping channel and there are large shipyards in Malta, so check. Court flexibility and decisiveness, this we haven't really had the opportunity to test it. Thoroughly, but under the ordinary sort of circumstances of handling or over this, it was good. And the process of clarity was very good. The only area for improvement that I would say when compared to other jurisdictions is remote auctions. So at the time that I attended the last auction, it was not possible to have it conducted via Zoom or Teams or anything, whereas other jurisdictions have done that. But other than that, it was overall a thoroughly good experience. And I think we just got lucky on the timing as well, which made it all the better. So, yeah.
Thank you so much. So we're going to move on to Mr. Paul Falzon. So Mr. Paul Falzon has been the International Transport Worker Federation's inspector in Malta since 2012, after being nominated by the General Workers Union in Malta as the ITF affiliate union. Mr. Falzon is a technician by profession. He spent the last 28 years working as a port worker, specifically as a stevedore, with involvement in the trade union sector, which eventually led him to being appointed as the ITF inspector in Malta. During his time as ITF inspector, mainly involved in the Flag of Convenience campaign, he has been engaged in several cases involving seafarers, leading to negotiations with ship owners, managers, and authorities, and even ship arrests. Since 2012, through ITF Malta, more than $5 million in back wages have been recovered, apart from facilitating medical evacuations of crew members, repatriations, reinstallments, and the safeguarding of the seafarers' rights in general. During the past years, he was involved in several crew abandonment cases, both in Malta and other countries, and in negotiating collective bargaining agreements benefiting the seafarers and the industry. So, Mr. Falzon, thank you very much for joining us. I've got your first question. So can you please share with us some of the challenges faced by crew members and yourself as an ITF inspector when an owner faces financial difficulties to the extent that a ship is arrested leading up to the judicial sale of a vessel with crew on board?
Martina, well, the main challenge for the crew is to brace themselves for a long-standing hardship. This is number one. And this is the most important because when we arrive at a situation that the ship is approaching a sale, it means that the owner has reached a point which would have been manifested early by lack of salary payment in the first place.
Mm.
This is mainly the first indication that a company is in difficulties. Salary payments, and then following that is lack of maintenance. Probably that would follow because the owner, of course, would want to keep the crew well maintained on board to safeguard his asset. But sometimes the difficulty is so big that lack of maintenance and salary payments are simultaneous. And I have to explain exactly what is lack of maintenance because it is something that it is affecting the human factor on board. So we are saying that there is no food or rationing of food, fresh water, drinking water, fuel for the generators, fuel for the main engines, because one has to appreciate that most of the issues arise when the vessel is at sea. And sometimes when we have, I mean, a lot of times when we have this lack of maintenance issue, for example, even in adverse weather, you know, the captain just cannot put the engines on because they have no power. They have no electricity. They are in, in blackout. Not only a danger for themselves, but even for the ships in the vicinity. So, and I can really, I mean, Dr. N knows and Dr. Adrian knows because we have been involved. In 2014, it was a classic case, kind of. It was a very important case because even at that time, there was no financial security clause. And I can say that during the 2014 events, they were discussing and introducing the financial security clause abandonment of the crew. And that was a turning point for everyone, especially for the crew. So these are the main challenges that the crew are facing is they have been abandoned. They are abandoned because they don't have the salary. They are abandoned because they don't have the provisions. And they are abandoned because they cannot go home. And these are the three criteria which qualifies the crew as having been abandoned in terms of the MLC standard A252. So we have a crew in this situation. these are the main challenges. Then they are calling their families, and their families are telling them that they are facing dire situation back home because they don't have the money to cope. So this is even psychological pressure on the crew themselves, apart from the hardship because they don't have the food, they don't have the electricity. Sometimes they don't even have power to charge their mobile. It's as simple as that. And these are situations, for example, as you said, correctly said, I have been involved in arrests because I'm not referring only to arrests in Malta, but we have had very difficult situations this year in arrests in Ghana and in Nigeria. And it was a very, and it's still, one of them is still ongoing, but it was a very, very difficult situation. So we had the crew of, without fuel, just breaking the wood on board the ship to cook.
My goodness.
So we had the captain, because of the pressure, he was hospitalized and he died in hospital because all this. And then, of course, this was amidst the COVID-19, where definitely we could not repatriate the crew because there was the travel restrictions and the airports were closed. So all this is coming to us. My challenge linked to this is to keep a united, instill confidence and reassurance in them. So this is absolutely important because it happens a lot of times that, sorry, yes?
Keep on going. I'm just indicating that you're...
Okay. It happens a lot of times, and this is, because this is such a vast thing, it's a human thing, but it happens a lot of time that either the master or the officers are still on the side of the owner, and they are not cooperating with the other crew, and of course not cooperating with ITF. And if the vessel, as Dr. Ryan can say, and everyone can say, if the vessel is outside judicial waters, you have to convince the crew at least to take the vessel inside, so then you can take legal action against the vessel. So this is a very, very big challenge, to keep a united crew and to together work along to keep them alive, to survive on board.
Thank you, Mr. Falzon. So we can lead on to your next question, which is how important is it for the ITF and the crew that the judicial sale takes place in a manner that is organized and efficient?
Not only organized and efficient, but expedited, I would say. It has to happen as fast as possible with regards to the crew. First of all, most of the time, nowadays with the financial security, the main creditor for us is the P&I. Because if we invoke the financial security clause and the P&I is engaged and the P&I is maintaining the crew and the P&I has to pay the 4 months of wages and repatriate the crew, then of course it's abrogated into their right. But then I become the most important for us. Now, the P&I would only pay the 4 months of wages upon repatriation. And this is a very difficult situation for us because we have to repatriate the crew. But then there is another issue. Who is going to replace the repatriated crew? So this is a very big issue for us, especially, it's everywhere, mind you, but it has happened here in Ghana and in Nigeria because the crew are stuck on board. So then we have to send the crew as fast as possible, but we need the replacement crew. Then there is the other issue. Most of the time, the crew will contact you after they have lost faith in their owners, which means they are owed more than 4 months of wages. Therefore, if the P&I is going to pay the 4 months of wages, we have to go for a ship arrest, possibly, or even participate in that ship arrest to cover for those wages in excess of the 4 months. Then there is the issue of the value of the vessel. If the value of the vessel is not good, it's a low valued vessel, we have a problem. Because the crew would want to stay on board, or rather, even if they want to leave, they cannot leave because they are not replaced. Then the more time they're going to stay, the accrual of the wages is greater. The possibility, all probability of recovering all the wages is less. It's diminished. So these are the main issues pointing towards one thing. We need an organized, an efficient, and an expedited process to get the crew off. Because, for example, I can tell you that the ship in Ghana, the claim was 234,000, and only recovered 100,000 from the court. So that is working against us. It needs to be organized, efficient, and expedited.
Thank you very much, Mr. Falzon. So correct, as you are saying, the more efficient the system is, the less human suffering there will be. Thank you very much. So next up, we have Mr. Peter Laurijssen. Mr. Peter Laurijssen is the legal director of the CMB Group. He graduated from the University of Namur in 1990 with a Bachelor of Laws, obtained a Bachelor of Philosophy from the University of Leuven in 1992, and went on to read for a master's degree in law and another in economic law from the University of Leuven and the University of Louvain and Neve, respectively. He is the CMB Group Legal Director and Editor-in-Chief of the Journal of European Transport Law. So welcome, Mr. Laurijssen. Your first question is, as head legal counsel at a large shipowning company, what do shipowners look out for when considering whether to participate in the judicial sale by auction of a ship?
Well, many thanks, Martina. Thanks also to Fenech and Fenech to grant me the opportunity to speak on behalf of shipowners community and express our views on judicial sale. To answer the question, what is a shipowner looking at when participating in a judicial sale? I would say, first of all, hopefully we're not looking at it from the angle from the defaulting shipowner whose ship is being sold, because then we would be in big trouble, of course. But looking at it from an interested buyer, a ship owner who wants to buy a ship, then the answer to the question is actually fairly simple and straightforward. And I will certainly not exceed the 5 minutes that were granted for this question, because the answer is the ship owner is looking to buy a high spec asset, the highest spec possible vessel at the lowest possible price. So that's what we're looking at as ship owner in a judicial sale. Now, knowing and seeing from statistics and on basis of practical experience and knowledge, we see that vessel prices in judicial sales tend to be lower than in normal commercial sales. There is, in fact, quite a large, considerable differential, at least in normal markets. I should make that caveat. At least in normal markets, quite a big differential between the market price in a commercial sale and the price in a judicial sale. So are ship owners happy then with judicial sales? Well, not always and not necessarily, because the low price of the vessel usually comes with a high price in terms of risk and adventure. And as Tilman Stein said before, bankers don't like adventure. Well, ship owners like adventure, maritime adventure. Same goes for investors, and looking at it from the viewpoint as expressed by Christos, but not too much risk and too much adventure, of course. So what are ship owners looking at in a judicial sale, and what do they aim to achieve is first and foremost legal certainty. Legal certainty, why is it so important? First of all, the ship owner wants to have a title to the vessel, and that title should be undisputable. So that's the first element of legal certainty. Then the title, second element, does not only have to be a title proving the ownership, it should also be a clean title. So the vessel should be cleansed of all maritime liens, mortgages, encumbrances of whatsoever nature. Very important. And then also, of course, the ship owner who bought a vessel in a judicial sale should be able to and has to be absolutely sure that the vessel can be deregistered from its current or previous registry, and that it's without too much difficulty, he can get the vessel registered in the registry in the flag state of his choice. Because the aim of a ship owner owning a vessel, of course, is that the vessel has to be able to trade freely without arrests. Of course, for the vessel to be able to trade, it should be able to register it. And in this, from this perspective, I would say the concern of legal certainty is not only on the side of the ship owner, but is also shared by all players in the maritime industry, be it importers, exporters, whose cargoes are being carried on board the owner's vessel, the banks financing the vessel, but also the banks financing the cargo under letters of credit. So any arrest, any stoppage of the vessel for whatsoever reason, which is related to the vessel's previous life, meaning previous before the judicial sale, is a severe hindrance of international commerce and international trade. So the aim of a ship owner participating in a judicial sale is that he can be certain of a continued trading of the vessel without disruption of the ship that was sold in the judicial sale. Now, worldwide, there are approximately a few hundred judicial sales per year, but the shipbrokers, they usually shy away from these deals for many reasons. First of all, because of the risks which are inherent to a judicial sale. Also because if it's a judicial sale, there are no commercial brokers involved, and they don't earn a commission, of course, which is the first and foremost reason for them. And that's why judicial sales get less publicity than commercial sales. So whilst there are a few hundred judicial sales per year, the big broking houses, upon inquiry, they informed that they usually see 2 or 3 auctions per year, maybe in a good year 6 or 7, or at maximum 10. So they are judicial sales. They are a lot less publicized and advertised than the commercial sales, which may help in terms of less interest in the vessel and lower prices when acquiring the vessel. Then we see also the jurisdictions where do the judicial sales mainly take place. Well, Malta has been mentioned. It's a very important place for judicial sales. Apart from Malta, we also see a lot of ships being sold in South Africa, Aruba, Panama, Gibraltar, and closer to home, for me at least, in Antwerp, in the Netherlands, in Rotterdam, there are quite a few as well. And as mentioned before, there is usually quite big price differential with normal commercial sales. But that goes as a price at the price in terms of risks, of course. And in normal commercial sales, we can cover those risks through clauses in the most typically used document for sales, being the Norwegian sale form, which is a BIMCO approved document, where clause 9 deals with the vessel being free of mortgages, charges, encumbrances, etc., and which brings us to the very important question of clean title, which I believe will be treated upon separately. So,
thank you. Yes, indeed, that is going to be my next question for you. In your view, how important is it that a vessel sold in a judicial sale by auction is transferred to the new purchaser with, as you said, free and unencumbered title, with clean title?
Well, the clean title is of capital importance, of course, to cover the risks that we just mentioned and we just listed. So, as I said, the clean title is a title, of course. It has to be clean, and it ensures that any claims which attach to the vessel from its prior life, prior to the judicial sale, that they can be fended off by the new ship owner. I must say this is a very important, very sensitive topic, because even if you get a clean title in one jurisdiction, this does not ensure that the vessel can trade to other jurisdictions. And a vessel, per definition, trades from one country, from one port to another. So, in fact, a vessel should have a clean title, which is valid in all nations across the world. In fact, the vessel should have an international passport, allowing it to sail from one port to another unhindered and unhampered. And this is the aim of a project which was taken up by CMI a couple of years ago, which led to the Beijing draft, which is a draft convention dealing exactly with the clean title, which should be valid in all jurisdictions around the world. And in the Beijing draft, a judicial sale should lead to a certificate of judicial sale of the vessel, and that certificate should be the basis of the free trading of the vessel afterwards. Looking at this initiative from the ship owners' side and the ship owners' community, in the beginning there was a lot of skepticism with respect to this project, because the ship owners felt offended, because they are, of course, a party whose ship is being sold in a judicial sale. So they were very much afraid to engage in this project. Another element, of course, was I would say, the certificate of judicial sale, the passport, so to speak, of the vessel to trade internationally. If a member state to the convention, UNCITRAL convention, would be a so-called rogue states, where there are only very limited, very rudimentary procedures leading to a judicial sale. I would say that judicial sale in such a rogue state would give a free passport for their for ships sold in their jurisdiction to trade worldwide, which was also frightening at first for ship owners when they were looking at the UNCITRAL and the CMI project. But looking at it more closely, the ship owner is involved from different angles and different aspects in a judicial sale. It's not only the defaulting ship owner whose ship is being sold, but as I just explained, answering the first question asked, from the aspect of the ship owner who purchases and acquires a ship from and in a judicial sale. There's also a third angle, because ship owners, they charter ships to other ship owners, to other operators, etc. And it happens more often than not that a ship owner or a series of ship owners are also creditors against the sale proceeds of a vessel that was sold in a judicial sale. Wherefore, as I said, there is more than one angle to the judicial sale, and the project, and I'm sure that some of the other speakers will elaborate a bit more on the UNCITRAL project. So the different angles for the ship owner to this subject, they necessitate that the UNCITRAL instrument, the convention, is a very balanced instrument. There should not be too much protection, of course, sufficient protection, but not too much for the creditors. It's of course important that the defaulting ship owner and his bank get their money, and that notification procedures and other procedural requirements, right of defense, are respected. Of course, also very importantly, the crew and the rights of the crew, as Paul has rightfully pointed out. But on the other hand, the profit in the judicial sale should be maximized as well. So if there is too much tendency versus protection of the creditors, then of course the certificate of sale, the passport of the free passport of the vessel, let's say, will have less value, because there will be more risks and more claims, liens might survive after the judicial sale. So looking at it from the angle of the ship owner at this project, it should be a very balanced instrument. And that's also where I'm very happy to participate in the project in the UNCITRAL working group, to look after the interest both on the creditor side, on the debtor side, and from the ship owning community in general.
Thank you so much for a really informative answer. So next speaker is Dr. Anne Fenech, who's sitting right beside me. Anne is a partner within the Marine Litigation Department at Fenech and Fenech Advocates, and has dealt exclusively with maritime issues for the last 34 years. She is the president of the Malta Maritime Law Association, a board member of the European Maritime Law Organization, and the founding board member of the Malta Maritime Forum. In 2018, Anne was elected as the vice president of the Compagnie Maritime International and co-chairs the CMI IWIG on international recognition of judicial sales, and is the CMI coordinator of the project that you have just spoken about, Mr. Laurijssen, at UNCITRAL. So Anne, your question. We have heard a great deal from our speakers about the importance of purchasing a vessel free and unencumbered in a judicial sale. In your career, have you ever come across a situation where a vessel is sold in a judicial sale free and unencumbered, but is subsequently rearrested by previous creditors?
I would have to say, unfortunately, yes, I have, Martina. And it really goes to the point which a number of speakers have made before me, including Peter just now. Because, of course, it's not only important that a vessel is in fact sold free and unencumbered in the state of judicial sale. It's equally important that when that vessel, after the sale, is purchased, is then able to travel to different jurisdictions and is then not reattached, rearrested by other creditors. And I have to say that as we were before UNCITRAL, which I will be speaking about a little bit later, trying to convince UNCITRAL that this was really a good project for UNCITRAL to take over, just in that month, by sheer fluke and coincidence, a vessel called the Bright Star was arrested one fine day in Malta, as vessels are fairly frequently. But this was a story with a very big difference, because in January of 2018, a vessel called the Trading Fabrizia was actually arrested by a creditor in Jamaica and sold in a judicial sale by auction, free and unencumbered. According to the law of Jamaica, when a vessel is sold in a judicial sale, it is sold free and unencumbered. The purchasers paid $10.3 million. They were Greek purchasers, paid $10.3 million, deposited the money in court, and the judicial court in Jamaica actually reserved out of the $10.3 million, $3 million to take care of the debt of this creditor that had arrested and initiated the judicial sale. So the purchaser goes off. 6 months later, the vessel is actually chartered. Charterers pick up an entire cargo of maize from Kafkas for the maize to be discharged in Venezuela. And as the vessel is passing through the Mediterranean, she stops off Malta, because of course Malta is equidistant from Gibraltar and Suez, and is a very popular bunkering location. The vessel stops off Malta, and the vessel is arrested, lo and behold, by this same creditor who had initiated the judicial sale in Jamaica, and for which there was $3 million sitting in court. And of course, I was called, and my first advice to our clients was, well, there must be a mistake, because you can't do that according to Maltese law, because Maltese law says, and I need to read this, where a ship has been sold pursuant to an order or with the approval of a competent court within whose jurisdiction the vessel was at the time of the sale, the interest of the mortgagees as well as of all other creditors in the ship shall pass on to the proceeds of the sale of the ship. So I told the owners, don't worry, we will get this arrest lifted. There must be a mistake. Just give me 24 hours and we'll have this done. So off we went to court and filed an emergency application asking the judge to declare the arrest illegal, because clearly there was a mistake on the face of this arrest warrant. And the court said, hold your horses, not so fast, because we sympathize with what you say. We probably agree with you. However, this is not an error on the face of the warrant. We're going into the merits here. So what that meant was that the arrest wasn't lifted immediately, which meant, of course, since the vessel was under charter and waiting for this maize to be discharged in Venezuela, that these owners who had just paid $10.3 million 6 months earlier had to deposit the amount, circa $1 million, as security to get the vessel released. But then we had to commence an action on the merits, full-blown action, to get the actual court to declare the arrest illegal. And now, when you look at that, if we're just to stop for one moment, what did this mean to the innocent purchaser? This meant to the innocent purchaser a disruption of his charter, with the charterers insisting that the vessel be released because the consignee was waiting for the cargo in Venezuela. After having paid $10.3 million, they had to put up security. we had to have the involvement of the P&I Club, who was going to finance all this litigation. We had, more importantly, the new mortgagees, because of course, when the purchaser actually purchased the vessel for $10.3 million, they had taken on additional security. So the mortgagee is the new mortgagee is suddenly faced with a situation where he thinks that the buyer that he had financed was a buyer which had taken a vessel free and unencumbered, and suddenly other creditors, which ought to have been taking their money from the ship's proceeds on the sale, suddenly make a reappearance. So, well, to cut a very long story short, we were engaged in no less than 73 different sets of proceedings here in Malta. So you can only just imagine the amount of cost involved and the length of time that involved. The reason why there were so many proceedings in the main action on the merits is because the arresting party dragged its feet no end after having arrested the vessel, refused to accept the notification of the proceeds in Malta, kept on filing additional applications to have the money which we deposited in court released in their favor, and consequently there was an enormous amount of activity. Eventually, and thankfully, in May of last year, the court decided and held in favor of the buyers, and the court held it is the view of this court that the proviso of Article 37, which I have just read, in other words, that part which considers the consequences of a sale after a competent court in whose jurisdiction the vessel was at the time of the sale, is clear enough to remove all doubts. There is no indication in the Act that the sale was not ordered by a competent court. The Jamaican court applied all the appropriate procedures in accordance with the law of Jamaica, and whilst it recognized the existence of the mortgage in favor of the defendant, reserved the sum from the proceeds so that the creditor's credit could be satisfied. This does not mean that the creditor loses his privileged rights, because of course the creditor could then go on to take the money from the amount of money made out of the sale. And in conclusion, the court said, the court considers that if this principle is going to come across a brick wall in its application, the recognition of a free and unencumbered title, it will create substantial problems for international maritime trade because it can stop the transfer of vessels by the order or approval of a court if the title transferred is going to be considered doubtful, and this notwithstanding the fact that, as occurred in Jamaica, the vessel was sold free of all mortgages, liens, and encumbrances. So that is the status of that case. A positive judgment. Unfortunately, there has been an appeal, so we're waiting for this appeal to be heard. So there you are. So I really touched this problem firsthand. We touched this problem firsthand, unfortunately.
Yes. Previous speakers have already mentioned some of the work that UNCITRAL has been carrying out, and we know that the working group 6 of UNCITRAL is currently deliberating a draft instrument on the international effects of judicial sale. You are the CMI coordinator for the project, so would you be able to give us a brief update on what's been going on lately?
Absolutely. Well, as most of the people who are following this webinar know, it was the CMI under the chairmanship of Professor Henry Lee from China that actually, after a number of years of deliberation, came up with what we call the Beijing draft. That was actually an international group was formed in 2014. In 2008, and then in 2012, eventually we had the first Beijing draft. Okay. And this was a draft convention which was going to deal with precisely the international recognition of judicial sale of ships. The Beijing draft was then finalized in Hamburg a couple of years later. And once a CMI draft like that was finalized, we had to find a home for this draft. We first, the CMI then approached the IMO, but the IMO were not particularly keen on the project at that time. So after approaches to the IMO, the CMI approached UNCITRAL. And UNCITRAL, from a trade perspective, needing certainty in maritime trade, thought the project to be very interesting and said, look, if you can go off and have a colloquium where you can gather a cross-section of the international maritime community. Let's see what they have to say about this. If they think it's a good idea, come back again and we'll take it from there. And in fact, we organized a colloquium in Malta, and 3 of the people we have with us today, Peter, Paul, and Tilman, actually were in Malta and spoke at the colloquium. We had 150 representatives from the international maritime sector, and the end result was, no two ways about it, concluding that there was an absolute need for there to be a convention whereby state parties would oblige themselves to give effect to judicial sales held in other countries where the title given in the sale was a free and unencumbered title. Recognition of the fact that when you buy a vessel in a sale free and unencumbered, then that title needs to be recognized and given full effect. So off we went to UNCITRAL. We presented our conclusions to UNCITRAL, and the Swiss government actually made a proposal to UNCITRAL. And to cut a very long story short, UNCITRAL agreed to take on the project. We are now fast forwarding to October 2021 in the 4th revision of the Beijing draft. Why 4th revision? Because the working group, working group 6 at UNCITRAL decided to actually take on this project. And the way it works is that 2 meetings of the working group are held every year, one in Vienna and one in New York. And at every meeting, there is deliberation, ending with revisions and amendments. And therefore, that revision is then discussed at the following meeting. Only last week, we had a meeting in Vienna deliberating the 4th revision. Notwithstanding the fact that we've had COVID and the pandemic, these deliberations and these sessions have kept on going virtually, and an enormous amount of progress has been registered. And I would very much like to share with our listeners and viewers briefly the structure of the draft. So most importantly, what this draft instrument is going to, what the purpose of the draft instrument is all about is contained in Article 1. And this states that the Convention governs the effects in state parties of judicial sales conducted in other state parties, which confer clean title to the purchaser. So that is what we're talking about. As Peter has just outlined, there is a structure in the entire convention which provides that proper notification has to be made of the judicial sale, and that the notice has to be served on a number of persons, including the owner, mortgage holders, registrars. There is an entire section, Article 4 rather, which provides for all of the persons to whom proper notification has to be given. But very importantly, and in my opinion, in a very novel manner, the actual notice also has to be given to the repository. The repository is going to be an IMO repository, because the IMO have what is called a GIS platform, GISIS platform. So the notice will be given to the repository. So any person can actually would be able to go into the IMO system and see whether a notice of judicial sale has been given. Once the vessel is in fact sold free and unencumbered, even more importantly, this country of judicial sale will issue a certificate of judicial sale, and that will in turn also be deposited with the repository. The convention then, of course, goes on to provide that on provision of this certificate to the registrar, where the vessel would have been previously registered. The registrar would then be obliged to issue deletion certificates, re-register. And finally, and most importantly, once there is the certificate of judicial sale, the vessel cannot be rearrested. So if we had a repeat performance of the Bright Star in Malta, for instance, all we would have had to do was produce the certificate of judicial sale, and the state party would be obliged to recognize it. As Tilman said earlier, we can write entire books about these procedures.
I'm sorry, I only gave you all 5 minutes.
Thank you, Martina.
Thank you. So our last speaker, but certainly not least, we have Adrian Attard, who's also a partner within the Marine Litigation Department. He has a wealth of experience in maritime claims, handling most types of wet and dry shipping disputes, ranging from collisions to salvage, from insurance claims to bunkering disputes. He regularly deals with ship arrests, mortgage enforcement, and judicial sales of vessels. Adrian also focuses on debt recovery and the enforcement of foreign judgments and arbitral awards in Malta. He graduated from the University of Malta in 2009, holds a master's degree from the International Maritime Law Institute International Maritime Law confirmed by the IMO Institute, and he was admitted to the Maltese Bar in 2009. Adrian obtained his PhD from Queen Mary University of London in 2019 and is a very active member of the Malta Maritime Law Association. So Adrian, your first question. In Malta, a judicial sale of a ship may take place by judicial auction or by court-approved private sales. Could you please briefly explain the key differences between the two mechanisms and the main advantages of each system? You would need to unmute yourself before you start speaking, please.
Thank you for the kind introduction, Martina. As you correctly pointed out, a creditor here in Malta, with an enforceable title in hand, may opt to execute its title against a ship in one of two methods, either by judicial auction, which is the more traditional approach, or the more novel court-approved private sale. At the outset, I would like to make a distinction and inform our audience that when we're talking about a court-approved private sale, this should be distinguished from an ordinary commercial private sale. A court-approved private sale is sanctioned by a judge. It is a judicial sale, and as such, it gives the purchaser a clean title. The vessel is transferred free and unencumbered. Therefore, under our law, one common denominator between the two methods of enforcement is that the purchaser always gets clean title, which, as Peter pointed out earlier, is key for anyone interested in pursuing bidding in a sale. Another common denominator with the two procedures is timing. Timing is key in shipping. In both procedures, it would roughly take between 4 to 6 weeks to conclude the procedure from the time when the creditor decides to pull the trigger and put in the application. Now, in terms of pros and cons, starting off with the context of a judicial sale by auction, the main advantage is that it is less costly than a court-approved private sale. Now, that said, in both circumstances, our law provides that the costs are recoverable from the debtor, from the proceeds of sale. However, what is legally recoverable and what can be recovered are two completely different things. A lot will depend on the value of the ship, on the amount of creditors out there, on the executing creditor's claim. A mortgagee who has a mortgage debt which exceeds the value of the vessel itself will inevitably be paying the court costs out of pocket. So that is one consideration which one has to take into consideration. Another advantage of the judicial sale by auction is the relative ease in which it can be done. The creditor simply has to file an application essentially to the court requesting the judge to appoint an auction date and a court-appointed auctioneer to oversee proceedings on the date. Compared to the court-approved private sale, the involvement is limited. I think, though, the main disadvantage of a judicial sale by auction is that here in Malta, the creditor has no guarantee or control over the sale price. There is no minimum reserve at which the vessel will be sold. So essentially and technically, a ship could be sold for much less than its market value if not enough interest is generated in the ship, or if on the day not enough serious bidders actually attend the auction. As Christos pointed out before, his involvement, he was very lucky because at those auctions, because it was in the middle of COVID, there weren't that many bidders who showed up. It is this risk factor, which I think Tilman was pointing out before, banks don't like. And as a result of precisely this risk factor, in 2006, the laws in Malta were amended to introduce the court-approved private sale. Now, essentially what the court-approved private sale mechanism is, it gives the executing creditor control, who has to take a proactive approach in the proceedings. He can source the market to find a buyer and to basically ask the court to approve the sale at a predetermined price. As you can appreciate, the main advantage of this procedure is that the bank or the creditor, executing creditor, has certainty insofar as what the sale price is going to be, how much proceeds there will be deposited in court. The second biggest advantage is that the executing creditor is actually involved in that process. He can actually help negotiate the price that will be attained. In fact, the executing creditor enters into an MOA with the prospective purchaser, which is made conditional to the court's eventual approval. I think essentially both systems have their pros and cons. And I think when a creditor has to determine which route to pursue, I like to say that they should consider and prioritize the 3 C's. That is control, certainty, and costs. And according to the circumstances at hand, determine which is the best way to proceed.
Thank you, Adrian. So I do have another question for you. We have heard about some difficulties faced by financiers, by investors, owners, and crew. Could you mention perhaps any other legal issues which could arise in a judicial sale, perhaps through your own experiences involved in them?
Sure. I think my distinguished colleagues on this panel have already given our viewers a good taste of the various difficulties the different interests involved face in a judicial sale. So I will try to limit my time to discuss one legal question, which does crop up from time to time with judicial sales and which is sometimes often taken for granted. And that is, what is included in the ship being sold? I think when we think of ships, the first thing that comes to mind is obviously the hull and the superstructure. And inevitably, these are usually always included in the sale. The second thing that comes to mind is perhaps all the machinery, equipment, and appurtenances on board. And whilst this is generally the case, it is not an absolute rule. A third party might possibly own equipment or machinery on board and try to come forward to bring its interest against that property. In fact, we were involved in a case a couple of years ago where a general cargo vessel, the MV Leonidas K, was arrested here in Malta, and the court had ordered the exclusion of an excavator digger which belonged to third parties and which was placed on board the deck of the vessel to allow for to assist with discharge operations. It seems that the Maltese courts, at least, would be willing to entertain a claim to remove third-party property in terms of machinery and equipment from on board the vessel, as long as the claim is brought forward prior to the sale, and as long as the property in question is not an integral part of the vessel, and therefore can be easily detached and removed from the vessel. Then there is also bunkers. It is not impossible or inconceivable that the bunkers on board the ship don't actually belong to the debtor ship owner. Indeed, most bunker suppliers have a retention of title clause in their terms and conditions. And if they are unpaid, may bring forward a claim, say, to have those bunkers excluded from the sale. There was a case in Malta where a local supplier did try his luck. However, he brought his claim after the judicial sale was conducted and argued it should have been excluded. And the Court of Appeal dismissed that claim and said that the objection should have been raised prior to the sale, not afterwards when presumably the bunkers had been consumed. However, that judgment does beg the question, what if a bunker supplier were to come forward beforehand? I think Christos pointed out that another thing which has to be borne in mind is what if there's cargo on board the ship? It's usually the cargo interest who will come forward and tell you that he has cargo on board, and generally speaking, they would try to discharge that cargo as soon as the vessel is arrested and way before a judicial sale is ordered. However, that is not always possible. As Paul commented, we were involved in a case involving the MVB Ladybug, and during the court proceedings, it transpired that this was a massive 230-meter ro-ro vessel, which was arrested by the mortgagee bank and which was scheduled to be sold here. It transpired in the proceedings that there were third-party trailers on board the vessel. And in the proceedings, the trailer owner came forward and showed evidence of his title, and the court did exclude those trailers from the eventual court-approved private sale. However, the problem was that these vessels were arrested at anchorage and did not have the clearance to come into port. So they couldn't be discharged prior to the sale. So what happened was the interested parties had to scratch their heads, find a workable solution as to what to do and where to discharge the cargo. In that case, they decided to discharge it at the next port of call after the sale was completed. I think lastly, and this is perhaps reserved generally for the more exotic world of super yacht enforcement, it is not uncommon that a multi-millionaire debtor may try to exclude luxury artifacts or personal artifacts from on board the sale of the yacht. A couple of years ago, in the Maltese courts, in the now infamous case of the MV Indian Empress, did precisely that, and at the request of the debtor excluded works of art and a piano allegedly given to the owner by Elton John himself from the eventual sale. So in conclusion, I'm talking about this point just to show how important it is that both the executing creditor and any prospective purchaser actually have a look at what precisely is being sold and whether anything has been specifically excluded from that sale.
Thank you very much, Adrian. So this brings us towards the end of our webinar. I know that there was one question in the chat. It's actually from Mr. Christos Mangos, and you want to tackle it?
Yes, Christos, yes, sorry.
Go on. So Christos asked, does Malta require claimants to secure defendants for their cost of defense? And this question popped up, and when you were discussing the Bright Star.
The answer is no. A claimant, such as the claimant in the Bright Star, would not have to put up security at all. There is a process whereby when a vessel is arrested, you then need to file an application for counter security, but that's a totally different process. The short answer to the question is no, Christos. So I think that really brings us to an end. Thank you so much, Martina, for moderating the event. Many thanks go to Tilman Stein, to Christos, to Paul, and to Peter Laurijssen for having joined us as the persons from the industry with which it has been our great pleasure to share some thoughts on this very important topic on judicial sales. This, as Martina has explained, has been the third in a series of 4, taking and replacing our annual conference on maritime law, which we have not been able to have because of the COVID pandemic, both last year and this year. So we decided to have a series of 4 webinars, which started in February, I think, of this year. We had one on Brexit, we had one on COVID and the cruise line industry. This is one on judicial sales, and we'll be having one on yachting at the end of November. No, the second week of December, that's right. So with that, a big thank you to all, a big thank you to the people who have tuned in and joined us this morning. We hope you have found that interesting. Thanks to Adrian and thank you to Martina and to all the team who have made this possible. Thank you very much indeed for joining us, and we hope you've enjoyed it as much as we have. Thank you.
Good afternoon.
Good afternoon.
Thank you very much.
Thank you.
Thanks.
Bye.